agree on a quorum. I would suggest a quorum of 3, and I hope my committee members would agree with me. 3 plus the chairman, I suspect. We can agree. There seems to be no objection, Madam Clerk, so we do that. Yes, member.
So just one request. I'm agree with the 3. No, I'm saying I'm agree with the 3. I believe that one of including the member, including the chairman.
Including the chairman. So you're going to suggest that at least one member will be from the opposition.
Yes.
Okay. So the request is amended a little bit in that we'll have 3 plus the chairman, and at least one member will be from the opposition. I'm now going to give...
Chairman, just for clarity, does that mean that if that member from the opposition is not present, then we can't commence? Because there may be more than the 3.
Yeah.
I just want to seek that clarity.
No, if there's 3, if it's just to be a minimum 3, but if it's more than 3, then it's fine.
Okay. When there is, if there are 3, the committee has the right to meet. However, that is composed. I'm asking for your agreement. If it's more than 3, then at least one must be from the opposition. And I see a shaking of head.
Mr. Chairman, I don't know why we're complicating attendance. We are members of the committee. Everybody has a duty to be here. So 3 members
plus
to curate the committee so the committee can do its work. I don't know why we'd make it any more complicated than that.
I like that approach because we're obliged, in a way, the service that we give to the country, to be here, and those who from either side must make sure that they're well represented. I think we will stay with 3 plus the chairman.
I'm not objecting. There are some sound reasons, but I accept that members of the opposition have to, like all the other members, have a responsibility to be here.
In fact, members of both sides, member, have a responsibility to be here, because the way this is now said, it says 3. I say nothing else. I'm now going to give a brief overview as to why we're here.
I'm sorry, Mr. Chairman. I'm
yes,
sorry to interrupt you before you proceed. Would this committee be contemplating the possibility of members joining via Zoom?
A good question. The committee wouldn't have any objection to that. Would that also give them voting rights?
Well, it does.
Chair, we would have in other committees incorporated a hybrid approach. And the hybrid approach allows for participation and voting. So I'm not seeing a challenge
so
where
move
that
on.
is concerned.
I agree with that. This is the age we're in. I don't have a problem with that. Okay, so we agree that it can be hybrid. Okay? You, of course, will inform the clerk if you want. And the clerk is Miss Kamisha Bailey, spelt with a C. Thank you. I was going to start with an overview, and it states as follows: the Insolvency Act.
Mr. Chairman, I don't want to upset your agenda, but could I just ask you, before you launch into the substance of that, I have introduced myself to the technical team present, but if perhaps we could just have some introductions for the committee, because I did see some faces there that I did not recognize this morning.
And the faces might change. Of course, we're here as the members, those you know who they are from the lower house and from the Senate. We have representatives here from the Insolvency, Supervisor of Insolvency, from the Ministry, of course, from the OPC, from Legal Reform Department, and from the AGC. So we have quite a support team here this morning. And to make it easy, I'm going to ask that we start from left, which is not normally where I start. But I'll start from left this morning, and we go right and we go around and come back. Thank you so much. Just introduce yourself for me.
Samantha Eaton, Deputy Chief Parliamentary Counsel, Office of the Parliamentary Counsel.
Yvette Sutherland Reid, Minister of Industry, Investment and Commerce. Senior Legal Officer. Yvette Sutherland Reid, the Minister of Industry, Investment and Commerce, Senior Legal Officer.
Fayola Evans Roberts, Deputy Supervisor of Insolvency, Office of the Supervisor of Insolvency.
And that's Fayola, not Fiona.
I'm Ferdinand Smith, Supervisor of Insolvency.
Just call him Justice. Everybody know him as Justice. Okay. Next, please.
I am Monique Adams, Crown Counsel in the Attorney General's Chambers.
Morning, everyone. My name is Ashley Marie All, the Assistant Crown Counsel at the Attorney General's Chambers.
Could you repeat it? I certainly didn't hear.
Good morning, everyone. My name is Yannick Douglas, Legislative Counsel here at the HOP.
The lady who spoke before you, I really didn't hear what you said. Maybe you should remove your mask to make it easy. It won't for a minute.
Mic check, mic check.
Good morning. My name is Cherie Spence from the Legal Reform Department.
Okay.
Morning, everyone. I'm Conrad Allen Brown from the Legal Reform Department.
Good morning to you all. My name is Kadeen Denny. I'm a legal intern at the Office of the Parliamentary Counsel. Yes, got it right.
Good morning, everyone. My name is Renee MacDonald, and I'm Assistant Parliamentary Counsel at the Office of the Parliamentary Counsel.
Thank you very much. Given the amount of legal advice we have in the committee and that slew of lawyers over that side, we should have no problem sorting this out very quickly. So now that we get through, we don't have to name the senators and the MPs. They know who they know who you are, I think. We've chosen quorum. I can now give my brief overview so we can move. Apologies. Madam Clerk, we need to record some apologies. We have apologies from Senator Don Webby, Member Donovan Williams, the Honorable Dr. Norman Dunn, Member Robert Miller, and Member Philip Paulwell, and Member Kerencia Morrison. We know that there's a particular funeral and other issues going on, so we record those. And now I think I can get into the business and say what this is about. The Insolvency Act, the Act, which was enacted in 2015, is administered by the Office of the Supervisor of Insolvency, OSI, a department of the Ministry of Industry, Investment and Commerce. The OSI, inter alia, regulates the licensing of insolvency practitioners, inspects or investigates the administration of estates by the trustees, records complaints regarding the administration, and intervenes in court proceedings where it is expedient to do so. The Office of the Government Trustee is also established under the Act to deal with individuals who are unable to access the service of a private trustee. The Act aids in the rehabilitation of debtors and the preservation of viable companies, having due regard to the protection of the rights of creditors and other stakeholders, and a fair allocation of the costs of insolvencies, with the overriding interest of strengthening and protecting the country's economic and financial system and the availability and flow of credit within the economy. The Act provides for the regulation of insolvency for both individual and corporate insolvency. It should be noted that Section 308 of the Insolvency Act provides that there should be a review of the Act by a committee of both Houses of Parliament within 5 years of the appointed date. Consequently, the Ministry of Industry, Investment and Commerce undertook the necessary consultation with the OSI to inform the proposed amendment under review of the Act. Cabinet's approval was sought and received. The proposed amendments reflected in the bill and approved by the Attorney General's chambers are now being presented to the Parliamentary Committee for consideration. That's my brief overview. I'm going to ask, though, that Justice Alderon give us a brief overview of the particularities that we will be looking at in this JSC. If you would, Justice, please go ahead.
Thank you, Mr. Chairman. This act, that is the Insolvency Act, it replaces and repeals and replaces the old Imperial Bankruptcy Act. And I'm just, as the chairman said, I'm just going to mention some of the sections and the provisions of those particular sections. Part 1, of course, is deal with the preliminary matters. Part 2 defines, gives definition of certain key terms and words. And Part 3, which is critical, introduces proposal. This is new to this jurisdiction. And this regime is very interesting, that is the proposal, because it provides where the debtor may make this proposal or arrangement with creditors. And if that proposal succeeds, then the debtor comes out of indebtedness or insolvency and can start afresh. And one of the key provisions of the proposal regime is that when a notice of proposal is filed, all proceedings against the debtor are stayed. Part 4 deals with acts of bankruptcy. What conduct would constitute an act of bankruptcy? And Part 5 provides for receiving orders, interim receivers, and so on. Part 6, this part provides for assignment. This again too is an innovative provision, because here the debtor may go into bankruptcy without the intervention of the court. He comes to the supervisor and applies for an assignment. That is, all his property to be assigned to a trustee for distribution in pari passu to the creditors. And part 8, this part identifies the effect of bankruptcy on the property of the the bankrupt. 9 deals specifically with bankrupt and the duties of bankrupt and the examination of the bankrupt by the trustee and so on. Part 10, this part outlines the procedure for the administration of the estate of a bankrupt. The Act provides that a trustee must be appointed to administer the estate of a bankrupt. And Part 11 provides for the appointment and scope of duties of the supervisor of insolvency. Part 12 deals with the power granted to the court to review orders, to abridge time, the time specified for the doing of any particular matter, and so on. And Part 13 provides for the matters of international insolvency and the foreign dividends and property of foreign currency. An interesting part of that would be when one looks at the provisions of UNCITRAL, that's the model law. Those are the main sections that perhaps might be necessary to mention at this time, Mr. Chairman.
Justice, before I ask my colleagues to comment, I just want, if you would do 2 things for me.
Yeah.
Say which party now can initiate the discussion and which party will be added. Just make that very clear. And the second one is what is, there is a request there for the supervisor of insolvency to give directives to the trustees.
Yes.
And could you make those, just expand on those for me before I ask my colleagues to comment?
Thank you, Mr. Chair. Might I deal with the second one first? That is the directives. Our Canadian counterpart provides for the superintendent there to give directives to trustees and receivers in relation to the carrying out of the provisions of the Act. In this jurisdiction, the power to give directives, that power is omitted. It's not expressly stated, but the Act provides clearly for the supervisor to supervise all matters under the Insolvency Act.
What you're seeking to do is to make it specifically clear.
Yes, sir.
That you can give directives.
That we can give directives to carry out the provisions of the Act. Yes.
And the second?
And the second one, what was it again?
The second one was who now has the right to initiate.
Right,
yes.
Thank you, sir. Right. Yes, as to who can make the proposal. Section 11 gives a list. But most of those persons who may make proposal are related to the debtor. But we wish to add the creditor. Oh, so sorry, yes. We wish to add the... Okay, Section 11 gives a list of persons who may initiate proposal. All of those persons are connected somehow to the debtor, like a receiver and so on. We are asking that the creditors be added to that list. And this is a recommendation from the, I was about to say, but it's from the World Bank, in short, yes. And it has been said that jurisdictions which allow creditors to make or to initiate proposals, that they have a very strong credit market, and that is attractive to entrepreneurs.
And just to make clear that the start of the process is the insolvency of the debtor.
Indeed, yes, sir.
Okay. Thank
Yes.
you very much. That's me. Colleagues, please. I see Senator. Senator Sarah. Okay.
Thank you, thank you, Chairman. Morning, Justice. Chairman, I was just wondering whether it would be, well, I'm proposing, because I think it would be useful, and particularly after the question you raised and the response given by Justice about why, for example, it has been recommended that a creditor be added to the list of persons to initiate. And in light of that, my recommendation is, given that this is a new, in quote, bill, act, 2014 was implemented, I would love to know, and I sat on the Bankruptcy Act then when this was coming into effect, Mr. Sutherland, you may recall, and I would love to know how has the implementation been over the last 8 years? Yes, and maybe not today, but perhaps for our next meeting, because I know you may need time to just do a presentation, but certainly how it has been, what are some of the main issues that you have, the challenges that you have encountered, which of course would help to inform us on the proposals that you're making. And certainly, for my purpose, I'd like to know how many persons have been, have utilized the act, the new act, certainly. Thank you.
We can certainly provide you with the information, but it's just for us to remember, though. I think we can make a note of that.
I think, Justice, I think the clerk to the committee will perhaps send a note to you on the question.
Yes, you should answer that in time.
Very well.
So we have the information quite accurate.
Okay.
Chairman,
yes, Senator.
Justice
Gale
would have, for the reference of the committee, outlined some proposed amendments.
Yes.
We would have gotten in our package the existing legislation, but just for ease of reference, I'm suggesting that at the appropriate time, we can be provided with the documentation to which Justice has eloquently referenced.
I am pleased to report that the ministry has this prepared. It is already sent to the Parliament, and in due course it will be circulated.
Okay.
Such efficiency.
Clearly, we have an excellent legal department. Thank you. Any other comments? Member Hilton.
Thank you, Chairman. Chairman, I think, well, we await the background notes, so to speak, from the ministry, because I think the amendments as proposed are two very interesting amendments. The one in particular on the creditor being on the list, I think that will, to my mind, need to be gone into in some depth.
Yes.
So there are some very clear understandings, because in a sense, the initiative, as it was originally proposed, seeks to give a measure of protection to the debtor.
To the debtor, yes.
And the extent to which the creditor now is able to initiate the proceedings, I would like, there are a number of questions in terms of the direction in which that goes, because the key to my mind to this, what was innovative about this, the act, the new act, the amendment to the Bankruptcy Act was the ability to enter into a scheme of arrangements without going into receivership and bankruptcy, so to speak, which then have the potential of destroying the business.
Yeah.
So I'd be very interested to know and to understand the basis
Just before you come in, Inspector, if you notice, I highlighted those two in particular. There are a number of amendments. I picked out the two that I believe we should consider very well, but I also added that the basis of either side, creditor or debitor, or creditor or debtor, initiating such a process is that insolvency has been reached. So nobody, the creditor is not going to put the debtor in insolvency. Insolvency has been reached. So that then gives either side with discussion and direction, which is what the supervisor is now seeking to do, to make sure the directions are clear going into it. So we're looking at it. I think you will find, member, that it's well covered, and if it's not, then we're here to make sure it's covered properly. Those will be circulated by Ms. Bailey in short order. Any other comments? Do you want to add to that?
Yes, just to,
Justice?
I won't repeat what you said, sir, but just to add something, that our experience has shown that many debtors could have been saved from bankruptcy if there was tenuous intervention. And we think that a creditor, provided, as Mr. Chairman said, the bankrupt is insolvent. Sorry, yes, the debtor is insolvent. Yes, yes. Then it might be helpful to the debtor for a creditor to intervene with the proposal.
And we will discuss it. You will have lots of time to discuss it. I'm glad I raised those 2 points, because I figure those are two critical areas that we need to look at.
Yes.
Clarity, Chair. So are you suggesting, Justice, that there's a period of a pre-kind of intervention?
Well, let me tell you what the Act provides. Once a notice of proposal is filed, then there's a stay. And the Act gives, I'm just going to cut short, up to 6 months to the debtor with his trustee to file a proposal. Yes.
So there's ample time. Any other comments that we have at this point before we get to the details? Let me get back to my agenda.
I just
Go ahead,
want to comment
member.
that the point raised by Member Binns earlier about our experience operating the Act since its passage, and some data around that I think would be very helpful.
That was asked for by your colleague,
Binns, yeah.
and that will be circulated by,
particularly
by the clerk.
particularly in light of COVID and the emergencies around.
Okay, that data will come as Member Fraser Binns asked at the beginning. Right? No more comments here. Then I'm going to formally ask that we seek submissions in the following fashion. I don't like to spend money. That's just my nature. Especially when it's not my money. I'm particularly careful with other people's money. So I'm suggesting we advertise in one newspaper. We use the social media arrangements in the Parliament. Every member must be tagged. When I get tagged, I will boost it. I have quite a few thousand followers. So I didn't say anything about popular. I'm sure many of them follow me for other reasons. So we make sure we boost it. We make sure, because a lot of people, especially a lot of young people who are skilled, a lot of lawyers use the social media pages. We need to put it in a newspaper. I don't know if we'll need a radio. I'll discuss that with the clerk if we should advertise on the radio. First of all, comments from members.
Mr. Chairman, it is my experience that Parliament does not have the most robust social media presence, but
Which is why you're being tagged.
I don't know that mine is particularly robust either, but can I also suggest that Parliament ask the GIS, which has quite a robust page,
Absolutely.
to give it some prominence?
In fact, what I was asking as well is that when JIS were to have posted it, that they would tag the ministry, and the ministry, and I'll then have my agencies. We have 20 agencies. One of them is Jumper, JBDC. I'll have all of them boost it from their social media plays, and by that time we cover most everybody. So we'll do it that way using GIS, who will tag Parliament and the ministry, and then we at the ministry will tag all the agencies in the ministry and get it out around the country and use one newspaper to do it. All right. Any other procedural matter? I've already dealt with the fact that the amendments will come to you shortly by Madam Clerk. And yes, Senator Allen.
Chairman, in addition to the public notices, are there organizations or other bodies that can be written to directly, advising them of this process that maybe they could contribute to?
In fact, when I discussed that, it was an oversight on mission by me. When I discussed that with the clerk, she mentioned, or no, my ACE legal counsel over there, PSOJ, JMEA, those kind of bodies will be JCA, all of them will be informed. So, and the Bar Association. Of course, a lawyer wouldn't, the lawyer started off with the Bar Association. I made sure that PSOJ and the rest were in. No, that's not true. She told me everything. But we will cover most everybody and invite them to come as well so that they are aware if they were to miss any of the notifications we put out.
I agree with, I've always agreed with that approach, Chair, and I want to also suggest, those groupings that are referred to as insolvency practitioners, like the Pricewaterhouse, KPMG, and the likes, to be a part of that. And we may want to consider FSC and the companies of Jamaica for their own, the government experience as agencies.
The COJ and so on.
Right.
But Mr. Sutherland Reed will handle all of that for us with the clerk to make sure it gets out. The clerk, of course, is the person who will be sending it out. So any questions, Madam Clerk, Mrs. Sutherland Reed and myself will be happy to answer those as to where it goes.
Chairman, is there a time frame that we are going to define? I mean, since between the sending out of the notice and the expected date of applications or submissions?
I must tell you, except for that we were obliged to send it out, I would have hoped that the whole thing would be finished today, but I was advised clearly out of my ignorance. So no, seriously, we're going to ask that a tight timeline be set. We're using social media. We're going to send direct mail. So I would imagine, Madam Clerk, 2 weeks?
Chairman,
if you don't get it out in 2 weeks, they're gone on holiday there, so it's 3 months.
The recess. And I would have seen situations where the time would have elapsed and you have late submissions. Are we inclined to accept?
If a late submission comes from a reasonable party, well, when we send this out, we ask them to come back in a reasonable period of time. If a late submission comes, then we consider it and deal with it.
Chairman, I've always found that whole question of late submission a little peculiar. The reason being, if we are still in the process of hearing submissions, then a submission is really not late. We have not completed the process, so they simply join the back of the line and come. I don't think, 2 weeks I don't think is really sufficient time for a lot of these bodies to be able to put together a submission, is my experience. But if we can at least start and get going, then they just join the back of the line if they need to make a submission.
Yes, sometimes that I don't always remember. I'm in government now. So the clerk is being wisely in telling me quietly here that at least a month is required.
Yes,
so
yes.
We're going to go that way, yes.
Yes.
So can we decide a month? Do you say a month? Can we live with a month? A month sounds to be reasonable, and we'll go for a month for them to return to us.
Chairman.
That's the chairman's prerogative.
Chairman, so then if it's a month, then we're really talking about, because, yeah, okay, the recess.
We have to reset the dates that we have for those meetings next week, because those we won't be ready. I saw in my calendar that we have 12th and 13th or something like that. It's a different committee. You're absolutely right. There are two of them that I'm sharing. So it's a different one. It's not this one. It's not this one. It's not this one. Okay. Okay. So, yes, ma'am.
Chairman, is it contemplated that we would sort of go through the bill from the policy perspective of the office prior to hearing submissions? I would certainly wish to understand what the policy position is and any potential policy changes that the ministry and the office would wish to see. So if we had that understanding prior to hearing the submissions, so that we could at least contextualize those submissions. We could get started with that even before the
Senator
submission.
Golden Campbell, I think one of those two dates that are in my mind is for exactly that. That we come back here as the JSC for the OSI bill to review the circulation that will be done on the draft amendments, so that we're prepared for when the submissions come. And if that's not on my calendar, Yvette, then I'd like to get that on, work with my office so that we get it back as soon after a week as we can to come back here to review it as a committee.
Chairman, yes, I agree with that, because justice would have piqued our interest in terms of the advanced proposals.
Right.
And so we are inclined to having those proposals so that we can familiarize ourselves with the policy direction before stakeholders start to intervene.
Come in, yes. Any other procedural arrangements that we need to consider this morning? And if there's none, then I'm going to accept Senator Gale's motion to terminate this meeting. And who will second it for me? Senator, I'm sorry, Member Hilton seconds it. Senator Gale moves. And our business is done for this morning.
Chairman, we have set a date for the next meeting. We have a date?
Going to ask the clerk to send it out later today, because I really have to, if I set any date at all, and it's not done through my office, it's wrong, because I have no idea what's on the calendar. So I'm going to ask you to give me a couple hours, and it will come back to you in a format that will be, I want to, Yvette, can you set up a chat for the committee for me, all of them? So we have this, the Jesse chat, so we can get it out quickly, and get back to you to say what the date will be and the time here. And if there's no other business, then the meeting for this morning has been moved and seconded. And is terminated now. Thank you all for coming. Thank you all so much. Appreciate it.